There's a famous Georgia Court of Appeals car crash case from 1970, where in a concurring opinion, one of the judges said, any juror who doesn't know that there is liability insurance in a case by this time should probably be excused by virtue of the fact that he is an idiot. Now, let's say somebody else causes a crash and hurts someone else. They have liability insurance. The insurance company is the one that gets to decide whether to accept responsibility. And the insurance company also gets to hire the defense lawyer and decide whether the case settles. So naturally, I'd get to get in front of a jury and explain that, right? Nope. In Georgia, you can't tell the jury there's insurance involved. We even have to redact it out of the documents to go to the jury. Everyone kind of just pretends it doesn't exist. And there is, to be fair, a reason for that rule. The law doesn't want juries deciding cases based on financial condition. The jury is supposed to decide the case based on the evidence and compensate for the full amount of damages, regardless of who's sitting on the other side. And I actually agree with that. The problem is that sometimes jurors just don't do it. And contrary to that 1970 opinion, to this day, one of the most common questions I get from jurors during deliberations is, does the defendant have insurance? And we just can't tell them. That question never comes up when the defendant is Amazon or Tesla, of course, but it always comes up when the defendant is an individual. So the jury is left wondering whether their verdict is coming out of just one guy's pocket when the answer is already sitting in the courtroom, just without a name tag.